This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
We're on page 21, chapter 4. We're 4 bullet points from the end, and we're actually halfway through the 4th bullet point from the end. Past consideration is no consideration. I've just told you the very sad case. I genuinely think it's a sad case for Rima Cardle. Roscola and Thomas is illustrative of the same point. It's, again, past consideration. It's no consideration. And this is about the purchase and sale of a horse. So in your horse list, you're going to have Roscola and Thomas. And Thomas, of course, you all of you work with a Thomas. There must be a Thomas somewhere in your office, or you must know a Thomas. So you should be able to remember Thomas. Roscola, I'm trying to help you remember Roscola. It's not a common English name. Roscola is not a common English family name. So the way you may choose to remember Roscola is by remembering the name of my older sister and the name of my younger son. That would help. Right? My younger son is called Ross, with 2 S's, and my older sister is called Carol, and if you change the letters of Carol, you finish up with Caller. So Roscola, my sister and my son, the other way around, my son and my sister. So Roscola. And Thomas you can remember. Any way in which you can help yourself remember these names, any way at all, any gimmick, any trick that you can use to remember case names is going to help. Some of you have just been down at the coffee machine with 3 of your colleagues who are on the P5 course, and one particularly, and only one of those 3 colleagues, one particular was saying how wonderful, am I wrong, how wonderful the laws, how she still remembers case names. This was years ago when she did it, and she's still there. She's got a daughter. She sits the daughter on her knee and says, Roscola and Thomas, past consideration is no consideration. And the Boots case and the Bells case, any way you can find to help yourselves remember. And those of you that work with others, like some of you there and some of you there, just test each other at break at work when you're having a 5-10 minute break. Just test each other. Just play with the law. And if you're on your own, play with yourself. I'll rephrase that. If you're on your own, just... Roscola and Thomas is about a horse, the buying and selling of a horse. And the seller has got the horse out of the field, it's all ready, and along comes the buyer in his big horse box, and they load the horse into the horse transport. And as the money changes hands, and as the driver, the buyer, is getting back in to drive the horse away back to his own house, the seller says to him, it's a good horse, it's a fine horse, it's free from any vice, it's free from any bad habits. This horse is a wonderful horse. And he gets it home, and wife is there, and the 2 little girls are there waiting to see the new horse, and it comes. And when he opens the back doors and the horse comes out, it's got foam around its mouth and its teeth are showing, and it kicks the man and he climbs back up. The children are there eaten. The horse eats the children. And the wife goes rushing back in the house and he phones the man up and said, you told me this was a good horse, a fine horse, free from any bad habits. And he said, well, maybe I was wrong. And so he goes to court. He wants his money back. He wants to take the horse back. He goes to court. And the court said, when exactly did he say this statement about it being a good horse? And he said, well, the horse was in the van and the money has been paid and I'm climbing up into the van when he said, this is a good horse. And the court said, this is past. The contract is complete. Whatever he says now, he may as well have been talking about the weather in Scandinavia for the difference it makes to the contract. The contract is finished. Now, let me tell you something about the horse that you've just bought is not part of the contract. So past consideration, the acts which have already been completed, cannot be incorporated into another, inverted commas, contract. These are just gratuitous, free statements which were made. He was not being paid for making these statements. It was just filling a time gap between starting to climb into your horse van and getting into your horse van. So past consideration is no consideration. You cannot incorporate into a contract which is completed some new element. Consideration must be legal and possible. 3 bullet points up from the end of page 21. It must be legal and possible. In the past, one of you, and I'm not going to identify which one, but one of you has given me grief by asking difficult questions, awkward questions. So if I'm not looking at anyone in particular, but if I were to say, Benita, will you do me a favour? I've got this flick knife here. Will you go and see if you can stab Vita for me, thoroughly, finally, fatally? Then if I pay Benita to do it, and then she doesn't do it, can I sue her for breach of contract? She's agreed that she will kill Vita. I have agreed and paid my £200, and now she's refusing to do it. Can I have my £200 back? Well, no, because although there is consideration moving from me to her, the payment of £200, and there's consideration moving from her to me, the killing of Vita, that consideration that she is giving is not legal consideration, and therefore it's not a contract. I will be prosecuted for plotting to kill someone. I will go to prison for it. She is £200 better off. And Vita continues to live. So it must be legal and possible. Consideration must move from the promisee, the next to the last point. Consideration must move from the promisee. There's a case, see if I can remember it. I can't remember it. I will remember it, but I can't remember it at the moment. It's just gone. There's a case about 2 young people. I can remember the first letter of one of the names, but I can't get any further. 2 young people are getting married. And the 2 fathers of the man and girl, the 2 fathers promised that they would each pay money to the newly married couple. And the father of the girl said he would pay £100. The father of the man said he would pay £200. This was an agreement between the 2. The father of the groom, the father of the man, paid the money, but then he died. The bride's father refused to pay the £100. So the groom sued his father-in-law. It makes for happy Christmas parties, doesn't it? Family Christmas parties. Hello, how are you since you last took me to court? The groom sued the father-in-law for the £100. And the father-in-law refused to pay, and it went to court. Did he have to pay? Let me give you a clue. No, he didn't have to pay. Why? Because the contract was between the fathers. There was no contract between bride's father and the groom. There was no contract. And therefore, to be able to sue on a contract, then it must be the promisee or the offeree, the acceptor, who sues the offeror. Or the other way around, the offeror sues the acceptor. But a person outside a contract has no right to sue. Remember this pen that I'm swapping with Benita? And she has delivered her pen to me, and I'm now refusing to deliver my pen to her. What right have you got to sue me, to make me deliver my pen to her? You have no right at all. And this is the area of law called privity of contract. And it basically says, there are exceptions, but it basically says that only a person who is a party to a contract has any rights under that contract. Only a person who's actually a party. I enter into a contract with Eddie. You have no right at all to enforce neither Eddie nor me to complete that contract. You do. You have. No, your wife doesn't. Your wife has. Well, maybe here in, dare I say, a third world country. Dare I say? No, I won't dare say that. In the UK, in English law, a wife is a separate person from the husband. In tax law, for instance, we have to fill in our own tax returns. It used to be the case that the man filed a tax return for him and his wife combined. But we've accepted that wives are just as much people. I don't want to go any further down this. I've got a room full of women and just two support. And probably if you know what's best for you, you won't support me. So, no, women are equal. There's no question. Women are equal with men. And therefore, your wife doesn't gain any rights just because I enter into a contract with you. She may, but it's an exceptional situation. Okay? And then finally, courts may imply a promise, may imply an implied promise to pay a reasonable sum. There's a case here from back in the 1700s, maybe the early 1800s. And it's about two men in prison. Lampley and Braithwaite are in prison in a place near Nottingham, a place called Newark. And Braithwaite is facing the death penalty, and Lampley is about to be released. And Braithwaite says to Lampley, when you get out, do me a favour, will you? Will you ride to London? Will you go to see the king? And will you get me a royal pardon, which means I won't be hanged? It's called a royal pardon. Will you get me a royal pardon? And that will mean that any crime that I have committed for which I am about to be hanged, we'll forget about it and I can continue to live. If you will do that for me, said Braithwaite, I'll see you right. I'll make sure that you're compensated. So Lampley did. On his release, he rode to London and he went to see the king. And I don't know how easy it was then, but it wouldn't be easy now. He went to see the king and he got the royal pardon, the king's pardon. And the king wrote out a little message that says, do not hang Braithwaite, and signed it George R. And Lampley rode back to Newark, and the rope is just going round Braithwaite's neck. He's just about to take the final jump. And he said, I've got the royal pardon, I've got the king's pardon, let him go. So Braithwaite was released. And then they went to the pub and had a drink to celebrate. And while they were in the pub, Braithwaite said to Lampley, thank you. I can't thank you really enough for saving my life. I'll give you £100 for doing this. And then later, he refused to pay. So Lampley sued. He said, I want my £100. But the £100 was only offered after the acts of riding to London to get the royal pardon had been completed. And therefore, it's like Roscoe and Thomas. It's like trying to add on something onto a contract which has been completed. So did Lampley win? Yes, Lampley did win. Why? Because there was an element of uncertainty. Braithwaite had said, I will see you right, I will compensate you. The only thing that was missing was actually a monetary amount, but there was a promise to pay a reasonable sum. And Braithwaite himself had quantified what he thought was a reasonable sum, £100. So that was the only thing that was missing, the quantification of the reasonable sum, but the reasonable sum had been promised. And therefore we did have a contract which just needed that little bit of extra completion, and the promise of £100 given in the pub gave that completeness to the contract. So Lampley did win and did get the £100. The court may be prepared to imply a promise to pay a reasonable sum. Determine reasonable. What's a reasonable sum? What's a reasonable sum, Archers? Oh, yeah, so sum which is reasonable, and it was Braithwaite himself who quantified this reasonableness of the sum to be paid, and therefore the court said pay it. So Lampley won. That's 21. 22. Another statement within this question that we read out earlier, question 24, part B1, says consideration must be sufficient but it doesn't have to be adequate. I've already actually covered that this morning very, very briefly. I've already given you or explained that principle. It has to be sufficient. It has to have, basically, it has to have a value. Any value. It doesn't matter what value, but it has to have a value. So if I undertake and offer to sell my car for £400, and trust me, my car is worth more than £400, if you accept that offer and you pay me the £400, I have to deliver the car. It's no good me saying, come on, it's a brand new Ferrari. You don't surely expect me to sell you a brand new Ferrari for £400. I'm in contract. You've promised to give me something of value in exchange for me giving you something of value. Therefore, I have to sell it for £400. So it doesn't have to be adequate. It doesn't have to be relatively similar to the value received, so long as it has a value. That's all that is important. And it's up to me to make sure that the price I'm asking is something similar to the real price. Or equally, it's up to you. If I offered to sell you my Ferrari for £4 million and you agree, it's up to you to make sure that you're getting £4 million worth of benefit or of product, of good. It's up to people who are of sound mind and body. That is, they have their full faculties. They can see, they can hear. They're not idiots, and an idiot is a technical expression. An idiot is a person with an intelligence level of less than 40, and they're not able to do anything. They can't enter into contracts. They have to have people to look after them. They're called trustees, and these trustees look after the interests of an idiot. But what if you're a lunatic? What if you're relatively sane most of the time, but just for the period of the full moon, you're affected by the magnetic pull of the full moon, and you suffer from lunacy? Can you enter into contract? I'm not looking at you particularly, Benita, but can you, if you were a lunatic, could you enter into a contract? If you were? Maybe. No, maybe. What do you think, Sandra? Can a lunatic enter into a contract? Yes, but if it's not a full moon and you're not under the influence of the moon, then you're a normal person. Define normal. If you're a normal person, and therefore, of course, you can. But if you're in a period of lunacy, you still can. So long as the other person didn't know of your condition. So long as you don't howl at him in the middle of the contract, so long as you appear to be normal, then yes, you can enter into a contract. But, now it goes back to the lunatic. If the lunatic can show, this is beyond the scope of your syllabus, if the lunatic can show that they were suffering from the effects of the moon, and the other party should reasonably have known that they were suffering from the effects of the moon, then the lunatic can avoid the contract. They're not bound to go ahead with the contract. Drunkards are the same. If you're drunk, if you can show that you were drunk and that the other party knew you were drunk. So on a Friday night in the middle of your wonderful capital city here, there may have been occasions when maybe I had maybe too many litres of your foul beer, and I'd gone to some restaurant, drunk. Well, how does the restaurant know that I'm drunk? I have a big meal and then refuse to pay. They don't know that I'm drunk. The way to deal with this is either be sick on the window of the restaurant or inside the restaurant, then have your meal, and then when they produce the bill, maybe if you can, be sick on the waiter as well, and then they would know that you were actually drunk and you wouldn't have to pay. You wouldn't necessarily wake up with both arms intact, or both eyes still in the right place in your head, or maybe some new makeup on your face in the shape of black and blue, but at least you wouldn't have to pay money. Okay, so sufficient, not necessarily adequate. I wandered off there into lunacy and drunkenness and idiots. and maybe I shouldn't have done. But the court will not look at the adequacy. If you are a normal person with normal mental capacities and physical capacities, for instance, you know I wear glasses, I can't read, my arms are not long enough, and by the time they are long enough, the writing is too small for me to read it. If I don't have my glasses, and you present to me a contract which you know I can't read, and you tell me that it is a contract for the sale of a car, and I sign it, but in fact it's a contract for the sale of a house, then you cannot enforce that contract against me, because you know that I was not able to read that contract. Maybe I'm a bit deaf. Maybe you explain the terms of a contract, but you know that I'm a bit deaf and that I've not properly heard you. What did you say? What? And if you know that I'm deaf and that I can't hear you properly, you cannot enforce an oral contract against me because you're not able to determine clearly that I've heard all the major details, all the material details. Glasses. Consideration must have some value. It must be therefore sufficient to merit the title consideration. There are things which don't have value. It's difficult to think of any product which doesn't have a value, but there are promises which don't have a value. And therefore, consideration has to be sufficient to have a value so that you can then give it the title consideration. And we've got here a case called Chappell and Nestle. We had another Chappell. We had a Chappell in a case earlier. What was the Chappell case earlier? Ooh, what area of law was the Chappell case? Yeah, you're right. Interpretation of statute. Yeah? And it was an illustration of the golden rule, wasn't it? Yeah, it was. And it was a colour case. What colour was it? Whiteley and Chappell. Well, this one is Chappell and Nestle. Nestle, the chocolate people. Nestle were promoting a new chocolate bar called Five Boys. Oh, isn't that interesting? I've not ever thought of that before. So far today we've had 7, 6 and 5. Haven't we? Within cases. What was the 7? Waswalls. Seven Oaks, where? We had Seven Oaks. And what was the job of the man? He was a jarina? In your language? Jarina? Gardener. In your language it's what? That's what I said. That's what I said. So we had Gardener and Seven Oaks. Then we had 6. What was 6 in? Oh my Lord, I feel like killing my parents here. What was the case involving Sigs? Sigsworth killing the farmer and his wife. Now we've got 5. We've got this Nestle launching this new product called Five Boys Chocolate Bar. And the Nestle promotion went like this. They said, if you will send us 3 wrappers from a chocolate bar, together with, and I'll change the value of the money, together with 20 pence. You give me 3 wrappers and 20 pence, I will send you, or Nestle will send to you a record of a record called Rockin' Shoes was the name of the record. Nestle will send a copy of Rockin' Shoes so you can play it on your record player, which is now history. But there was a retail price limit which was imposed by the distributor of this record, Rockin' Shoes. It shall not be sold for less than 35 pence. It shall not be sold for less than 35 pence. And Nestle were getting rid of it for 20 pence and 3 chocolate wrappings. And so the promoter of the chocolate bars, the publicist, the distributor, Chappell, sued Nestle and said, you're selling our records for 20 pence. They should only be sold for 35 pence. You're in breach of a resale price agreement, and therefore we're suing you. And Nestle's defended it. They said, we're not selling it for 20 pence at all. We're selling it for 20 pence and 3 chocolate wrappers. What do you do with the chocolate wrapper? Take it off the chocolate, screw it up and throw it away. Well, no. If there's a record called Rocking Shoes for saving these chocolate wrappers and putting 20 pence in there, then they have a value. In court, it was established that when Nestlé opened the envelopes, they tipped out the 20 pence, they got the chocolate wrappers, they did not even count them. They just screwed them up and threw them away. Do they have a value? Yes, they do. And they have a value. Whether it's value 15 pence to get us up to 35 is irrelevant. They were obviously of 15 pence worth of value to Nestle's. They have a value because it is proof that people are buying this chocolate bar. It doesn't have to be you that bought it. You could be walking home from the tram, you could be walking home and see a chocolate bar wrapping, then you pick it up off the street and you wave the snow off it and take it home and iron it. And there's another one, I get 3 apples. I've got 20 pence, yes, you can get your record. It doesn't have to be you that bought it. That's not what Nestle's were interested in. They just wanted to know that someone had bought their chocolate bars. So they did have a value. And therefore, they were not guilty of breaking this retail price agreement. The value that they have is talked of in terms of if something is a value but it's a very little value, it comes into the very bottom case, the bottom case on this list. But it comes into there. If they have a value but it's a very little value, that is a rather larger image of a piece of pepper, a little peppercorn. A peppercorn. And if it's something minimal, it's called, it has a peppercorn value. Does that have a value? When you go to the shop, when you go to Remy and you buy pepper to put in your pepper mill, to put on your pizzas, does any individual peppercorn have a value? Well, yes, it does, because that, together with the other peppercorns in the container, that is what you've just bought. It may have only minimal value, very tiny value, but it has a value. And the court has expanded this idea and said a peppercorn has a value. And even though I don't like pepper, and I throw away the corn, it still has a value. It's just that I'm not interested in the value that it has. So even though it's minimal, it still has a value. And peppercorn rent, when you rent premises at a ridiculously low price, that's called a peppercorn rent. So I'm back on bullet point 3 here. It's not sufficient if it's in accordance with a natural duty. Not sufficient. It's not enough. It doesn't merit the title consideration. I'm not bothered about adequacy. I'm just looking to see whether consideration in these cases can be classed as having a value. And you'll see those first 3 points there, bullet point 3, 4 and 5. It's not sufficient if it's in accordance with a natural duty, if it's in accordance with a legal duty, if it's in accordance with a contractual duty. But then the next 3, if it's over and above a natural duty, if it's over and above a legal duty, over and above a contractual duty, then it is sufficient. So the case is, this first one is in your colours list twice, isn't it? It's white and blue. White and blue it. White and blue it was about a father-son situation. And the father was asked to lend money to the son, £500. And after a period of time, the father said, what about that £500 you owe me? When do I get that back? And I said, oh, Dad, don't make me get it back. Don't make me pay it back. Please, it's embarrassing. I don't have it. Don't make me pay it back. And he went on and on. The father said, what about the £500? And the son said, Dad, let me off the debt. Don't make me pay the debt. Dad, don't make me pay. Please, Dad, don't make me pay the debt. On and on and on. And the father said eventually, shut up. And the son said, I'll shut up. I'll stop complaining if you will let me off the debt. And the father said, okay, I'll let you off. Just shut up. The father then died, and the instruction to the executor was, on my death, collecting all the money which is due to me, including £500 from my son. And the son fought it. He said, my dad let me off the debt. He said I didn't have to pay it back. And he went to court. And the court said, what did you give your father in exchange for him waiving his right to get this £500? And the son said, I stopped complaining. I stopped giving him an earache. I stopped saying, Dad, let me off the debt. And the court said, but that's just a natural duty, isn't it? Is it not your natural duty not to give your father a headache by complaining? Do you not see it as a natural consequence of being the daughter of your parents that you should treat them with full respect and honour? Of course it is. So is this performance of a natural duty already owed? Not to hassle your parents, or in an extreme case, not to kill them. So performance of a natural duty, simply not giving your father grief, is not enough. It's not sufficient to merit the title. It doesn't have a value. All you're doing is what you should already naturally be doing. The next one down, it's not sufficient if it's in accordance with a legal duty. It's Collins and Godfrey. And again, Colin is an English person's name. Godfrey is also an English person's name. Spelt slightly differently, but close enough. So if it's in accordance with a legal duty, now there's a strange word I'm going to write up on the screen here, and I've not the slightest doubt that you've never heard of it. And it's called you may correct me and tell me I'm wrong. You recognize that, of course? A subpoena, it's called a subpoena. And a subpoena is an order which is issued by the court. And if they need you to attend at a court hearing, they will subpoena your attendance. They will issue the piece of paper. It will be formally served on you, and it says, you, in court, next Wednesday, 10 o'clock. And you go. You have to. This is a contract which you are in, but you're not a volunteer to that contract. And it's therefore classed in the area as being a unilateral contract, a one-sided contract. You, in court, Friday afternoon, 4 o'clock, and you have to go. And if you don't go, for some good reason, if you don't go, like I was run over at 3 o'clock on my way to court, and at 4 o'clock I was being operated on in the operating theatre, that's why I wasn't in court. Unless you have a good excuse like that, then you are in contempt of court, and you face a prison sentence because you didn't turn up in court when you were told to. Collins and Godfrey was about Collins, who was a witness to an accident. And Godfrey was the solicitor of the injured person, and Collins had seen it. So Godfrey contacts Collins and says, will you turn up in court and give evidence on behalf of my client, and I will pay you £5 for your trouble and your expenses. Then the court issues a subpoena on Collins and says, you will attend in court and give evidence in this case. So Collins did. And then he turned to the solicitor and said, can I have my £5? And the solicitor refused to pay. So Collins sued, and the court said, but you were subpoenaed. You had to attend anyway. So the performance of a legal duty is not sufficient to merit the title of consideration to support another contract, a separate contract. Because you had to do it, you can't claim that act as being in support of another agreement.